side, and we're ready to start with Joseph Octave versus State of Florida.
May it please the court. Good morning.
Wait just 1 minute.
They didn't even tell me how to work the clock yet. So. Got it. Okay. Thank you.
Good morning. My name is Brenda Newton, and I represent Josette Octave, who was entered a plea in the Orange County Circuit Court to neglect of a child. This case can be decided on the basis of Maxwell v. State, which was decided after the briefs were filed, and the first 3 pages of the interview that was conducted with Ms. Octave. And I would also like to throw in the little chart that the dissent in Knight, which was the supplemental authority from the state, put in, which shows that in both Roberts and Knight, the defendant was given some idea that he had an attorney, a right to an attorney, before questioning. This case involves...
was there a written Miranda rights form that was signed in this particular case?
No, sir. Judge O'Kane...
Oh, is it in the record?
No, it's not in the record. Judge O'Kane asked that, and I don't think anybody directly answered her. But she says, can we all agree there was no written waiver? And,
okay.
And nobody disputed that.
In some of the testimony, there is an officer testifying about a card that was used and that was read. Does the record establish that the investigating officer at the time he gave the Miranda warnings, let's call it the second interview, that he had the card or a card in his possession that was exactly like the one used in court?
Now, he didn't say whether he had the card. It was established there is an Orange County Sheriff's card.
Well, I know he said he had a memory of it because he's given it so often. My question, though, is did he have a card in his possession that he either used specifically, that is word for word, or one that he had and he paraphrased?
I'm afraid I can't answer that. I don't know that he had the card in his possession, but he did agree with the prosecutor that he just has it memorized, doesn't even need a card.
Right.
And this is what you get on the first 3 pages of the interview. You have a right to remain silent, and basically he secures her agreement. Yes, I want to talk to you. That's why I came down here in handcuffs. I'd like to talk to you.
I'm going to ask just one question to help me. The Supreme Court has held that you don't have to give a verbatim recitation of Miranda as published by the Supreme Court, or even the card that you have, but that you must sufficiently cover the elements that the Supreme Court dictated be read to a prisoner in custody. Why is it, in your case, you argue that it was not sufficiently covered or paraphrased or conveyed to this defendant?
Well, first of all, she said, when he said you have a right to remain silent, she says, I answer you. If you talk to me, I answer you. And he says, yes, ma'am. And then it does appear that she understood that if she chose to, could choose to be uncooperative and not say anything to him. Then, after that's established, he says, you have a right to an attorney, and the state will pay for one if you need one, if you can't afford one. He doesn't say when. He doesn't affirmatively mislead her that it won't be till later. He just says, oh, and then you have a right to an attorney. And when he asks, and she establishes that she understands that by saying, yeah, I see it on TV. And I may not watch enough TV, but I don't see a lot of public defenders coming down, to an interview in the jailhouse on TV. It's just not. And he tells her she has a right to an attorney after he's gotten her to agree to talk to him. We're going to have this interview. Oh, and you have a right to an attorney, and one will be provided if you can't afford it. And there's nothing that refers to when she can have an attorney. And again, the little chart in Knight's dissent is helpful, because even in Roberts, they said you have a right to talk with a lawyer and have a lawyer present before any questioning. And in Knight, they added, if you decide to answer questions now without an attorney present, you still have the right not to answer my questions at any time. He doesn't, Detective Clark didn't tell Ms. Octave anything about whether she could stop questioning, just that if you choose to, you can not talk to me. And she said, I want to talk to you. Okay, we got that established. Now, let me tell you also, you have a right to an attorney, and if you need one, the state will pay for it if you can't afford one. I don't think that tells her we'll call the public defender's office right now and have one come down and talk to you. She's never given any direction or reasonable opportunity to understand that she could have an attorney at no expense advise her about whether to talk to this detective that she's already agreed to talk to. Now, there's a...
What statements were made at the house, as opposed, I know she was formally arrested and taken to the jailhouse, but what statements did she make at the house? She repeatedly said, I checked him, and Detective Clark was asking, why didn't you check She
him?
wasn't in custody at that time, was she?
She hadn't been arrested.
No. So regardless of whether Miranda was given or not, I mean, those statements are not suppressible. They're admissible, I think.
Well, our argument is that she was in a custodial setting.
Well, how was she in custody when basically she was the one that initiated the conversation, wasn't she?
Yes, she entered the room apparently waiting for her
Explain to me
paycheck.
how she was in custody at that time and why Miranda would even apply.
She was staying at the home, the children's home, because she was waiting for her paycheck. She had no place to sit. She stood between two of her supervisors, not fellow employees, her supervisors. There were 6 officers on the scene, and the setting was custodial. And I suppose it depends on whether Detective Clark...
Didn't she leave as soon as she got her paycheck?
As soon as she got her paycheck.
Nobody attempted to detain her?
Right, she got her paycheck
Told her she
after
couldn't leave?
I'm sorry.
No one told her she couldn't leave?
You know, and
No one even asked her to stay?
Nobody told her she could leave.
And there were not 6 officers in the room. There was 1 officer, 1 detective in plain clothes, and he was talking to the supervisors, and she walked into the meeting. She was not summoned there. Is that accurate?
That's correct.
And then left when she got a paycheck?
Yes, sir.
How do you call that custody? If you can come and go as you like, you're not called in, you're not brought in, you walk in and then you leave.
Well, the test is what if a person had an objective basis to think they were in a coercive situation, whether they were a suspect. And actually, that scenario is more relevant to what happened later when the same detective...
You would agree, though, that if we determine that she was not in custody at that time, that whatever statement she made comes in, regardless of whether the Miranda warnings were deficient or not?
Yes, sir. That was your question. I'm sorry. But Detective Clark he said he couldn't get her to answer his question about why didn't you check the sheet, and she kept saying, I checked him, but then 5 months later, she didn't know who he was, but she clearly understood her Miranda rights, according to him, because he remembers them. He's got them memorized. But
You sort of lost me on that. I don't understand.
just what happened at the interview in November.
Okay.
That what would be useful for the prosecution is that she didn't say, or she didn't ever explain why she checked the sheet. Well, she wasn't understanding the question, but she understood the Miranda rights 5 months later.
Are you arguing that her language skills in some way came to bear on both of the questioning periods or the statement periods?
Yes, sir. It's a factor to bring in on whether she understood what the detective didn't tell her.
Wasn't it proven that she'd been speaking English for over 20 years, sometimes in Canada, sometimes in the United States?
Well, she was in Montreal. She could probably get by with a little French or Creole.
Well, didn't it show that she took a Florida test and passed it to become certified?
Well, as the psychologist said, he couldn't find any record of all these educational certificates she said she had, but he thinks she believes she did have all that certificate.
Well, didn't the court, the lawyers, and her lawyer all speak to her in English?
Her original lawyer, yes.
Well, the court, I assume it says during the plea colloquy, it was in English, not with the
There was an
translator?
interpreter at the motion to suppress and the plea hearing, but the court recalled talking to her
In English?
at the earlier proceedings, and she agreed with everything the court said. And she agreed with Detective Clark. The language factor is just a factor because it's not so much Creole versus English, even though her own employers couldn't understand her when she called about the child's distress. But the language barrier basically is a layperson versus the law. And the trained detective understood what her rights were. But he was talking to somebody who's in the lower 1 to 2% percentile for IQ. between extremely low and borderline at best.
She didn't interpose a defense of mental incapacity or retardation or...
No, it's just a factor to consider, and how well she understood from watching it on TV and what this detective was telling her. Did she understand she had a right to stop the questioning at any time and to have an attorney with her during the questioning? And if you read the first 3 pages of the taped interview and the reasoning in Maxwell, it's...
Why didn't you order the tape up of the interview?
Oh, I don't know. I guess I didn't realize it wasn't here. I didn't think that through. And I could certainly do that.
Would you like to reserve any time?
So thank you.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. Let me start with the custody issue when she was at her house. Although it was portrayed as this owner's situation, she wandered into the room. So the first statement, she wandered into the room, they asked her a couple questions, she got her paycheck, and she left. That was clearly not custody. So the first statement was clearly the motion to suppress was properly denied. The second statement was taken at the police station. She was clearly in custody then. There's no contention that she wasn't. So the question is that one is whether or not the Miranda warnings were sufficient and whether or not she understood them. It's our position.
Wouldn't you agree that Maxwell does require reversal?
No, I don't agree with that.
How would you distinguish Maxwell and Russell?
Well, there were a couple problems in Maxwell. First of all, they didn't tell him that an attorney would be appointed if he couldn't afford one. There was never any mention of that in Maxwell. So that's, a big portion.
But there was also a defect in that he wasn't told that he could have an attorney present during questioning. And in Maxwell, you'll see a number of Supreme Court decisions, both U.S. and Florida Supreme Court decisions, that say that you must advise the accused that they have the right to have counsel present during interrogation.
Right.
All right. So the question is, and obviously Maxwell says that you don't have to say that verbatim from a card memorized from the decisions, but you have to give them advice and statements so that a reasonable person would understand. So where is that advice in this particular case in the colloquy where they were giving this defendant Miranda rights? I don't see it anywhere.
Where it is, Your Honor, they have to reasonably convey the substance of Miranda. So they told her she had the right to remain silent. They talked about that for a little while.
Well, she had a right to a lawyer.
Right. She said they had the
Can't
right
afford one,
to an
no
attorney.
appointment.
And if
Right.
they can't afford one,
Where's the statement that she's entitled to have the attorney present during questioning? Where is that?
when they told her she had a right to an attorney, and when you take the whole warnings in context, it conveys that she has a right to an attorney. There's no limitation. It doesn't say you have a right to an attorney before questioning.
Roberts, Maxwell, there are a whole line of cases that say that simply advising a defendant that you have the right to an attorney is not sufficiently advising them of the fact that they have the right to have the attorney present during questioning.
Well, I disagree that Roberts says that.
Okay.
Roberts, the warning in that case was you have the right to an attorney before questioning. There's a line of cases that distinguish before versus...
But there are cases after Roberts as well, especially out of the Fourth, that say that simply advisement of the right to counsel does not mean that you have the right to have the attorney present during questioning.
The cases that I've found in Florida, except for Maxwell, putting Maxwell aside for a second, the cases out of the Fourth, they're all dealing with warnings where they say you have the right to an attorney before questioning. There's a line of cases, and they're cited in that Fourth DCA case, that the federal courts have umpteen opinions on this, and there's a split of authority. And some of the cases they say, yeah, before questioning, it's kind of misleading. It imposes like a limit on the attorney, versus if you just say you have a right to an attorney, there's no limit implied in there. It's when you take it in context, you know, we're not going to use, you know, anything we say can be used against you. You have the right to remain silent. They talk about questioning. You have the right to an attorney.
Here's a concern I
We'll give
have.
you one for free.
Let's assume that she did understand English, and that is not a bar. Let's assume that the first meeting was not coercive. There is ample evidence in the record that she was not told that she had a right to an attorney while the questioning was going on, and she could call for an attorney, and if she could afford one would be appointed. With her limited education and the allegation that she's from a foreign country where she yields to authority, isn't that why Miranda should be followed precisely by either reading it substantially or so that it conveys that you can have a lawyer while I talk to you about these criminal charges that may cause you to go to prison?
That's exactly what Miranda is for, but there's also cases saying that you don't have to use any magic words.
But you have to convey that you have the right to an attorney while questioning is ongoing. Isn't that accurate?
That's, yeah.
Well, aren't you building an inference on an inference that if I say you can have an attorney, you should assume that it means right now?
I think when you phrase it like this, I think in the context of you have a right to an attorney before questioning, an argument could certainly be made that that implies that once questioning starts, it's all gonna stop. But when you say you have a right to an attorney, blanket, that's it, there's no limit implied there.
But why does the Supreme Court say in some cases in Florida that you have to tell them that they have the right to an attorney while interrogation is ongoing?
Because that's the gist of Miranda. The question is whether or not that reasonably conveys that. When you say you have a right to an attorney, and anything you say is going to be used against you, and you have a right to remain
Here's
silent.
what Ramirez versus State says, and it's a Florida Supreme Court decision. And I'm quoting,
Okay.
Suspects must also be informed that they have a right to an attorney during questioning, and that if they cannot afford an attorney, one will be appointed for them without cost. It doesn't say that you have the right to a lawyer. It says they must be advised that they have the right to have the attorney present during questioning. And so, I mean, and so you're saying that it's just simply sufficient to say that they have the right to a lawyer.
I'm saying that they have a right to a lawyer reasonably conveys that you have a right to a lawyer. There's no limits on it. It doesn't start at some time in the future. It doesn't end. You have a right to a lawyer, period.
Isn't
And you
that
have
the
to take it
exact
into
argument
context.
that was rejected in Maxwell?
Well, there were other problems in Maxwell as well.
I mean, that argument was rejected. The holding of the court was that we're going to reject that argument. The state argues that implicit in the warning to Jonathan that he had a right to an attorney is the warning that he had the right to have an attorney present during questioning. The argument is very clearly rejected in Maxwell, isn't it?
Well, but there was also the additional problem that they never told him that one would be appointed if he couldn't afford it. So we argued in Maxwell unsuccessfully that telling you have a right to an attorney doesn't, we argued that you can infer from that you have a right to an attorney during questioning and free of charge. And this court rejected that argument. So the question is, now we're on a different scale. They told her that she had the right to an attorney free of charge. There's no question about that. They also used similar language. You have a right to an attorney, period. The question is whether that missing language in Maxwell made a difference as compared to this case, and it's our argument that it did. There were two problems in Maxwell.
Is there any record evidence that the officer did, in fact, have in his possession an approved Orange County Miranda card? Or is it only that he memorized it to the best of his ability and then conveyed it without reading it?
The record evidence, they asked him about that, and he said what's reflected in the transcript, which is in the supplemental record,
Right.
is exactly what I told her. I didn't give her any additional warnings. So we don't have an argument that he showed her a card.
Okay. And there was none
There's nothing in
signed.
the record to support that.
So it stands or falls in the transcript we have where he
Yes.
does not precisely mention that you have the right to an attorney during questioning?
Yes, it does stand on that.
Here's what Miranda says, and I'm going to again quote from Miranda, the Miranda decision. And it says, accordingly, we hold that an individual held for interrogation must be clearly informed that he has the right to consult with a lawyer and to have the lawyer with him during interrogation. To consult with a lawyer and to have the lawyer with him during interrogation.
Right.
And it says they must be clearly informed of that. And
Right.
so your argument is that simply telling them that they have the right to a lawyer clearly informs them that they have the right to consult with a lawyer and to have the lawyer present while the police are questioning.
It's our position, Your Honor, that all of the warnings given in this case, taken in context, and you can't just isolate them out, reasonably convey the right, that you have an absolute right to a lawyer, because it's given in the context of you don't have to talk to us. We're going to appoint you a lawyer free of charge if you need one. And anything that you say now can be used in court against you, and you have the right to an attorney. It doesn't say before questioning. It doesn't limit it in any way. So it's our position that that blanket statement, given in the context of all the other rights, which was missing in Maxwell, but we have here, that in context reasonably conveys the rights required by Miranda. If the court has no other questions, I ask you to affirm. Thank you.
Thank you, ma'am.
Okay, thank you very much.